And in a year, I became the leading counsel, and I was looking after all litigation in USA, in Singapore, in London, in Mauritius, in other countries, and all the counsels were working under me.
And welcome, my dear friends, once again in the Superlawyer YouTube channel. Today, we have with us esteemed Ashok Kumar Singh, sir, who is a senior advocate. And we would like to start the interview by asking the most important and most pertinent question. Sir, what inspired you to pursue law, and how has been your journey from the beginning till the time when you are doing arbitration and dispute resolution cases with so much ease?
My father was a government servant. I have seen the bad days in my life. He was a small, hardworking government servant, an honest man, and to survive with honesty. And at that point of time, when I studied profession way back in 1977, 78, it was difficult job. So I thought of not joining any service and doing something different. Business I could not do because I had no money. So ultimately, I thought that I should adopt a profession without money or less money. I can continue, I can do something different. So I thought of joining law, and in 75, I joined law faculty, Delhi University. I passed out in 1978. When I passed out in 1978, prior to that, I started going to the courts. At the point of time, there was no concept of internship or something. My senior would take me in the court, and normally it was understood that I am a new clerk to him. So sometimes it was very humiliating and insulting when somebody asks you that you are a new clerk and you are not in a position to say yes or no. I started the profession, to be very frank, because I wanted to do something different and I had no money to invest in the business. So I thought, let me try the profession. Second aspect of it, why did I come into arbitration and dispute resolution? Initially, I started as a criminal lawyer. As on date also, I love to do criminal work. Criminal work is my blood. In 1986-87, there was a gentleman who was an additional general manager in Delhi Transport Corporation. He gave me a challenge in arbitration. It was against NPCC. And his CMD told me, Mr. Singh, even if you get it compromised in 20 lakh rupees, I will be the happiest person. 20 lakhs rupees in 85, 86, 87 was a big amount. With the grace of God, it was the first case in my life. I did it, and a nil award was passed. But still, no award was granted to NPCC. So it brought a major change in my life. I realized that besides the criminal clients, when you deal with the civilized, highly placed client, you can invite them at your place, you can invite them in your office, or you can chit chat with them, you can have a cup of coffee. But with the criminal client, you can't have all this liberty. And secondly, I realized that good money was transferred to me even at the point of time. I charged per hourly rates and per hearing rates. I was the only counsel in Delhi Transport Corporation who was paid this much amount. So thereafter, in some other government departments, they tried me. I worked in Delhi, out of Delhi, and gave good results in arbitration also. So the people started liking me to work in arbitration also. So this is all matter of chance that I started working in arbitration. Suddenly, slowly, around 2010, somebody from US approached me. He wanted an Indian counsel to represent them in an international arbitration, and it was in different jurisdictions: London, Singapore, Mauritius, Cayman Island, Isle of Man. So I thought that he would pay me some lakh of rupees as a fee, but he asked me to give my fee schedule in hours. And he indicated that he doesn't want a petty lawyer. So indication was that you can charge a good amount. So it gave a twist in the life. I started working for them, an international company, as an Indian counsel, because the Indian laws were involved, Indian properties were involved, so they wanted someone who knows about civil law, criminal law, income tax, everything. English counsels were very, very cost for them. So they wanted someone to assist them, to assist English counsels. With the passage of time, within 6 months, I was made by them as a second leading counsel in the matter. And in a year, I became the leading counsel, and I was looking after all litigation in USA, in Singapore, in London, in Mauritius, in other countries, and all the counsels were working under me. And they found that I was much cheaper in comparison to English counsels who were charging very heavy. And the best part of it, which I must share with you, Divya, it was a matter where a claim of about 1700, 1800 crore rupees was filed against our client. So when we enter into, we look into the entire file, we wait a claim, and we issue the notice for the counterclaim. Within few months, the chairman of the claimant approached for a compromise. And the best part is, without contesting the case too much, they gave to our client an Indian currency 192 crore rupees. So claimant didn't get even a single penny. The respondent who had to defend the case, to whom we were defending, they got 192 crore rupees. Obviously, we also got a good amount of fee and a confidence level that yes, we can do internationally also in various jurisdictions and we can give good results to the clients internationally also. That confidence which we, virtually I should say that we earn by our hard work. It is not only I who did it, my team also did. There were other lawyers who were working with me. They also helped me a lot. So that was another change in the life. So then I thought that I should now confine to arbitration more instead of criminal. Because in criminal, every time in the initial stage, the people would try to find out a laborious lawyer, good lawyer. So I was getting plenty of work. I got plenty of work. I am not boasting, but I consider that I was one of the biggest counsels in district court and thereafter in high court also in criminal side. But suddenly things changed with the passage of time. The client started approaching with an idea, sir, you know such and such person, you know the government counsel, this was not my cup of tea. So I slowly started drawing from there because it was a little disturbing also. And secondly, when you say no, I don't know, I don't believe in this sort of practice, they would not like to continue with you, they would like to go to others. But in arbitration and civil practice, I realized that people appreciated your labor, they appreciated your knowledge. And with the passage of time, even till date, I'm getting good work from domestic as well as international clients. I have no problem. So this is the way in which I came to arbitration, all with the grace of God. Nothing, and a little labor also. Little labor, little zeal to work, little enthusiasm to work, that is required also.
I must say that you are being too humble. Yes, it is God's grace, but it has been your labor as well. So since you picked up such a new field of arbitration and the field was absolutely new in 1986, as you said, during this course of time, what kind of changes have you seen in commercial dispute resolution as well as the kind of arbitration which we are seeing nowadays? There must be some difference because we suddenly opened up for the world, India especially in 1991. So you must have seen a lot of change as you had shifted from criminal to arbitration and commercial dispute resolution. We would love to hear that, sir.
There have been a lot of changes. As far as the arbitration is concerned, it's a very difficult question which you have asked. I know a lot of people would get annoyed with my answer. Now it is dominated by a particular class. India wants to become the hub of the arbitration. It is said so. But what I feel is it is something, a slogan which we have given that let it be hub of arbitration. If it is so, then why about 36% of the arbitration in Singapore are of those Indians? Why about 30% arbitration in Hong Kong or about 33% arbitration in Kuala Lumpur are of Indians? Why they are not coming back to India? Why they are not engaging to Indian arbitrators? Why they are not relying upon the Indian councils? Why they are not relying upon the system which we do have as on date, though it is improved a lot. System doesn't carry that much weight. The people who have to somehow work in the system, that is very important. How the arbitrators are appointed, who are the arbitrators, how do they behave, how much are they charging, is it feasible for an international client to engage them, what is their tone, temperament, that is very important. Because international client would not like someone to be dictated as we normally get. Secondly, internationally, when we go out to conduct the matter, we know that early in the morning at 9 o'clock we have to report, or 9:30 you have to report, and 10 o'clock we will start. It will continue up to 5 o'clock, and we are paid for that. Hourly basis, arbitrators also paid for hourly basis. Amount is also very reasonable, 500 pound or 600 pounds, 550,000 or 60,000 rupees in Indian currency per hour. Even the arbitrator charge that much amount. But here it is a little costly affair. You would appreciate. Normally, arbitrator, though schedule 4 is there in domestic, that is something different. But in international arbitration, there is no schedule. Arbitrators are charging the fee according to their own choice. Normally, charges are 2.50 lakhs fee per hearing of 2 hours or more than that. Good time is wasted in looking into diaries and find out the actual dates. Then 2 hours sometimes are completed or not completed. It is something, which pinches to the international client. If you ask me that 2.50 lakhs means 1.25 lakh rupees per hour, which is a little higher in comparison to international market rates. They give you a good amount. It doesn't mean that they don't make you the payment. Their payment is much more than our payment. But they give in different shapes. Hourly preparation of the case. After preparation, when you prepare for the drafting of the awards, they pay you good amount. For consultation, meeting in between, they give good amount. But hearing always go there in one go. 10 to 5, 10 to 3, 10 to 4, whatever is the time given over there. And in a very disciplined manner. That is lacking somewhere here because of the reason that we don't have any institutional arbitration, if you ask me. There are only very few institutions over here. And those institutions are also somewhere in state-wise, somewhere in region-wise. So international clients, they are unable to choose to whom they should go. Whether Mumbai International Arbitration Center, the International Arbitration Center, or Chennai International Arbitration Center, or Chandigarh International Arbitration Center. There is no choice. So you have to develop a particular city. You have to find out a particular city. And then you have to develop that city. Like in Singapore, they have said develop Singapore. Singapore, it doesn't mean that it is entire Singapore, but it is. There are so many other international arbitration centers working there. I am also advisor to them. But you have to develop a particular center. You have to choose this. And that center should be completely out of judicial interference. Completely. It should be in the hands of only independent persons. All right. Highly placed arbitrators, highly placed persons who have got good knowledge in the arbitration, only they should run it. Then probably we can make a difference. And this previously, because the arbitrations are not too much over here in the country, so system was a little different. I still recollect when I would go to any arbitrator, he would welcome us like anything, invite us for a cup of tea also, and will treat us just like, his own child. Things are changing. Those days have gone. Now, we have become more commercialized. That is the difference I am finding. Secondly, the labor, this I don't blame the arbitrator in this. Judgments are totally, nowadays we are getting 100-page judgment, 200-page judgment. So now, by the time you rely upon a judgment, another judgment comes which is contrary to the law which is decided earlier. Sometimes in a month we get 2 or 3 judgments which are not in line to each other. Nobody is following what is decided earlier. Sometimes it creates a lot of difficulty for the clients also. Their position is also very bad. Now the provisions are also made very stringent. Normally should be considering international practice, but we have to look into our practice also, our country practice also. In section 34, there is no chance to get any relief unless and they issue something different. So is the case in section 37. I'm not accusing anyone. Possibility and probability of out of 100, 1 or 2 or 3 or 5 arbitrators becoming dishonest cannot be ruled out. And just imagine the plight of those clients. What impression they would carry if they are not able to prove their case, despite knowing that something injustice has been done with them. Some judgment should also be there that when the client is finding such a great difficulty, when injustice is done with the client, my experience is that most of the arbitrators with whom I am working or other the arbitrators with whom I am working, they're very honest and dedicated. So India is a very big place. We have got the maximum arbitration, just we have maximum arbitration in the world. Most of them are not institutional. When they are not institutional, they are the small places also where the arbitrations are going on. Where even the area in charge or market pradhan, they are also conducting arbitration. Those arbitration are also covered by section 30. So I feel that we are making the laws very stringent, but time has come that we should also look into those persons who are, despite having the good case, losing it because of the reason that whatever arbitrator decides, the court says that we are not sitting in appeal, whatever it decided, it is prerogative. So that sort of thing has to also be looked into in different aspects. Those few changes have come, which are also good and which are also bad. Every aspect has both the sides, good and bad. So I know this is very difficult to explain all these things. You feel a lot of things which you don't want to explain openly. But yes, there are a lot of changes are required. A lot of changes are required, and time has come that we have to make arbitration virtually should go to the roots of the society. We should join others, people of society also as an arbitrator. The lawyers, senior lawyers, engineers, architects, academicians, all those who are entitled for it, who want to become chartered accountant, company secretary. Whenever I go to the institutions for sometime for teaching the law or some other aspect to them, the question which they normally ask is, sir, why we will be appointed arbitrators sometime in our life? I can't say anything to them because appointment is done by someone who is not under my control. Or we all know about it, so I don't want to open it again.
So thank you so much for at least openly saying certain things which are supposed to be said. There is a possibility someone else, there may be some change that can come up. If time would have permitted, I would ask a lot about arbitration because that is one of my favorite subjects, and I usually do research around IP arbitration and other aspects which are still not taking place as we would have expected in India. But so that being said, with your extensive legal career, you being involved in so many places at one time, and with your criminal law practice, with your arbitration practice and everything, how do you find time to teach as a professor at Sanskriti University, and the kind of role that helps you see the balance? How do you find that particular balance between academia, legal work, and where do you see that helps you build that narrative around your life? Because it is not that common in India for a legal professional or a lawyer to be that active academician, but it is seen outside India, not in India. So how did you choose to do that, and where do you find that time and energy?
When I was in London in conducting the matter, I realized that most of the judges would work as a part-time lecturer. My son also studied over there. My daughter studied in US. So I always got an impression that the judges would come in the late evening or sometime 10:30 or 11 o'clock, and the message will be floated that he is coming to discuss about the legal proposition, and they would come and teach to the students. So during Corona, I was in touch with my juniors and we were discussing various aspects of law, arbitration, IBC code, other criminal law. Online, whatever knowledge I do have, I was sharing with them. At this point of time, one or two universities approached me that if I can online speak to their students. One of the university made me an honorary professor. So I'm not going very regularly to teach, but whenever they require my attendance for particular subject or for a practical experience to the students, then obviously I will love to go there and to share my experiences. What I have realized, and I personally feel that we should, because the universities are also finding it difficult to call us, because their curriculum is totally different than what we have in our mind. Whatever we teach and when we go and when we discuss about the practical problems, then the students find themselves in a great difficulty. Sir, we have taught this much, but you are saying that it is to be done like this. Why it is to be done like this? Practically, there is so many problems in the life. You know it very well. A student who has learned criminal law, when he comes in the court, he has an idea just like Shatrughan Sinha would come from the back and say, my lord, how can you do it? And the matter would be decided in 5 minutes. At the time of bail application, hearing will take place or evidence will take place. This sort of idea always remains because they're fascinated by the pictures, by the films. To make them understand that it is very difficult. Internship, I always tell my intern that this is not something to teach you. This is something to teach you only discipline in the office. Come on time, sit over there, learn the legal proposition, go at your appropriate time. If you don't learn the discipline, you won't be able to be a good lawyer. So we can't make them the lawyer in 3 months or 4 months or 2 months or 6 months. No, we can't. We have to just make them understand what is the law, so that tomorrow they should not get frustrated and run away from the profession. And you won't believe that 85% the persons, the lawyers or young lawyers who join the profession within 2 to 5 years, they leave the profession. They don't continue. Especially who are coming into not in corporate, in trial cases, they get frustrated much earlier. Reason being, what they have in their mind that is not there. To get client is a difficult job, then to get money from the client is a very difficult job, and then to get a relief from the court is the next most difficult job. And unless until they get the relief, the client would not repeat them. They want get new clients. So soon they get frustrated because they have to get settled in life also. They come in the age of 23, 24, and by 28, 29, 30, they are not able to earn even 50,000 rupees per month. They get frustrated. So we have to, besides the legal education which we are giving in the universities and college, we have to make them aware about the practical things also. So I thought of let's do something different beside what is written in the books to inform them about the practical aspect of the legal profession also. And getting time is not a difficult job. Because I recollect one of my seniors, I have a great influence of that gentleman, is no more in the world. He always said, Vyast, wo hai jo ast vyast hai. So if I have to take out the time, I will take out the time. If I don't have to take out the time, I will not take out the time. I just manage. I don't have to take up that much work which I can do. It is injustice with the client also, it is injustice with myself also, it is injustice with my family also. To take only that much work which is required. Initial stage, yes, I did a lot of work. I was working from morning from 7 to 12 o'clock. I was conducting 20 to 5 cases in a day. Now I don't do that much work. So I feel that whatever is required for me, the God is giving me, I'm happy with that. So to take out time is not a difficult job. It is only that you have to manage your schedule. You don't have to do too much work. You have to give proper time to the family, proper time to work, proper time to the staff, proper time to your hobbies, proper time to yourself also.
Thank you, sir, for being so positive about taking out time, which usually all of us get the answer that you don't have time how to do it. So on that note, I would like to ask you the next question related to the new entrants to the legal field and all the kind of stress that you were talking about, that after 5 to 7 years, usually they get frustrated because they have that filmy thought that this is how trial court will work. What would you suggest to those entrants and such kind of thought process, how to build this inherently that later when they enter the profession, they do not feel frustrated? There must be something, because as you said, in your early days, you used to take up 25 cases a day. That's a huge thing, but you must have managed that in some manner. So if you could impart some thought about that, because that will be very helpful to the new generation as well.
For the newcomers, we can give so many advices, but before giving any advice, it is better that we should change ourselves. I still finding great difficulty in persuading my friends to give at least some amount to the interns or to the junior lawyers. If you go to district courts, you will find the position is also very tough for them. If you have to ensure that good lawyers should join the profession, we have to support them for 3 years. Maybe 2 years, maybe 3 years, maybe 4 years, maybe 5 years. So it's become the duty of every senior who is keeping a junior that at least minimum possible expenses should be met out, that much amount be given. And it is a great, help to them in the initial stage. If they are not asking the money from even if asking the money from father or mother, very small amount they're asking for, otherwise they are happy that, yes, I am getting 20,000, 15,000, 25,000, 30,000, something which I am getting. And for a trial lawyer, when you join a law firm, the matter may be different. But learning the law firm is a little slow, which I'm not against them. I have all respect for them. It is slow. A person who is working in the district court, working from the zero and then learning from the beginning, then he becomes a very good lawyer. He knows when the appeal will be produced, what is to be done when the bail application is to be moved, how the bail bond is to be moved, how the charge is to be framed, how the civil suit issues are to be framed, what is the meaning of rejoinder, what is the meaning of application, what is the meaning of return statement. He knows a lot of things. So before giving a suggestion for the newcomers, I will request my all colleagues who are well placed in the system, they should extend their hands of help to newcomers. That will be much better. The moment you do it, many of them will stay in the profession, only would prove to be good lawyers. Second aspect of it is the newcomers, which I am finding is that none of the newcomer wants to go to the lower court. Out of 100, you will find hardly 5 or 10 who are going to the lower court. Everybody is interested in coming to the High Court or the Supreme Court with the father's car, enjoying a cup of coffee or some snacks or smoking with your friends and then going back in the evening with a new white shirt, new coats, with a smiling face, but they don't appreciate that coming over there and spending 2 hours, 3 hours, 5 hours, 10 hours even per day, that is not going to help them in any way. High Court has its own limitation. Supreme Court has its own limitation. Basic law is to be learned in the lower courts. which nobody wants to learn. So they also have to change the temperament. They have also to decide what do they have to do. People come to me, sir, we have to work in High Court only. That's right. You will get a chance to work in High Court, work for 5 years in lower court, and then you will be in a position to understand the basic concepts of law, basic concept of practice, basic difficulties of practice. So probably we should also make them understand that better to work 2-3 years in the lower court and then come to High Court. 2-3 years, 4 years, 5 years in the lower court, and then come to High Court and Supreme Court. So 90% those who start in High Court and Supreme Court, 85 to 90% they leave the profession between, because there is nothing. You can work in the law firm for 2 years, 3 years, 4 years, 5 years, what will happen thereafter? You have to show your worth. They are not going to pay you throughout the life without showing your worth. And you will show your worth when you will learn something. The learning process is a difficult job. So my humble advice to all newcomers is that they should spend some time in the lower court, learn the beginning, whether in criminal side or in civil side, learn from beginning what is a civil law, what is a criminal law. Basic Civil Procedure Code, by Limitation Act, Specific Relief Act, or Stamp Duty Act, or other provisions of the law, which are very important in life. Or in criminal side, then CRPC, IPC, Evidence Act, they should understand what is there. And then they come to High Court, try their luck, probably they might be more successful in comparison to what they are today.
That's such beautiful advice, sir. I really wish that people will listen, at least learners will listen, because this is something which will make sure that they build their foundation properly. And that foundation is something which will help them grow. So as you have interacted with so many international and national clients parallelly, kind of ethical complexities, I would say, have you encountered any while representing such clients? And how did you upheld that kind of principle of justice and fairness that we always talk about as lawyers? How has it worked for you? How have you gone through the whole process?
It depends upon person to person, simply. If I am honest, I am honest. If I am not, I am not. If I have to do something, I have to do. If I don't have to do, I don't have to do. I always request everyone in my family as well as in my office, learn to say no. The moment you learn to say no, all this problem, ethical problem, no problem, will never come in your way. If you find that something your conscience doesn't permit, say no. What is the problem in that? That is the best way out. Because of the reason that you are not saying no and you are continuing in a particular thing and you are finding a lot of difficulties, it happens. Right? It happens. Secondly, most of the people, if you ask me, I have yet to find out what people say a profession is degrading. Yes, in some aspect, I do appreciate it is. But I have not met in my life, 45 years practice, somebody has approached me for any work. A case I am doing, and even I'm sorry to say, but even no High Court judge, no Supreme Court judge, no minister, they know me very well. They are very close friend of mine. No member of parliament ever approached me. Look, we are doing this matter and we want you to do in this fashion. So you have to build up your image. The moment your image is good, you won't find such type of problems. Whether it is domestic or international, nobody at least approached me. And they have to approach me to say, sir, we have to do in this fashion. No. My prerogative, my decision, you have given the problem to me, I will discuss with you, I will suggest solutions. If you are happy, well and fine. If you are not happy, give me a counter solution. Let me examine that if they are good enough. That's right. No illegal business in my profession, in my office. No hanky-panky in my office. If I am sure, I'm not going to face any difficulty. The problem comes when one doesn't maintain his own character. Then the problems comes. Otherwise, the problems don't. At least I have not found any such problems in last 45 years. Not even a single person has approached me. And I have done the second largest case of the country, in addition, about 15,000 crore rupees matter. It is not a small amount. I have done other matters, 500,000, 2,000 crore rupees matter I have done. I have been senior legal advisor to so many government departments, but nobody ever approached me. Nobody ever tried to say, Mr. Singh, you have to do something which is not as per your principles. And I don't boast, but to one of the biggest business houses in the country, when I was a legal advisor of a particular department, a particular work was assigned which was worth millions and millions of dollars. And it was totally on the basis of their merits. So it depends upon person to person. Otherwise, I have not found any difficulty, and I don't feel that anyone should find a difficulty. One is a man of character. But a man of character, you might find difficulties. People might consider you egoist, might make an opinion different about you. They say he doesn't come to our chamber, or he doesn't come to anyone's chamber, or he doesn't hear to anyone. That sort of impression they may carry. But in my heart, I am happy that I never did anything in my life.
So that being said, when you were mentioning that the second largest case of 50,000 CR, if you are comfortable sharing some details and how it made a course for you, a difference in your life on your professional front as well as personal, because this definitely is the biggest thing which one can hear, because you were handling such a huge case. How did it bring change in your life?
Look, as far as the case particulars are concerned, they are always confidential. But I will again say that there are two things which count a lot in all these things. Your reputation, you are a laborious lawyer, you can make a planning very well. If one knows how to prepare a matter and how to get the ultimate relief, this planning is to be made in the initial stage. At least good work is to be done on this before starting a matter. Someone who was very highly placed in the government of India, after retirement, he became advisor to that company. So he had seen me working for about 8 or 10 years. And he had seen that I dealt with the matters worth millions of rupees and got the positive results. So he recommended my name and that matter was assigned to us. We worked for about 6 months just to make a strategy and to prepare the reply. And it was I must say that very well prepared matter, very well prepared matter. I'm happy that I worked on that matter. Just sometimes we get different challenges also. One of my friend, I must say friend, because at one point of time he came to me only when I was conducting the matter of Delhi Transport Corporation. He came to know about me. Then he became the CMD of a department. He assigned me a matter, look, despite our best efforts, we are unable to recover the money from this gentleman, which is politically very highly placed. With the help of the officers concerned, who were also very nice and dedicated, and my staff, we worked day and night, and it was very difficult to, it is just like we have to catch the snake and the snake would go run here and there. We got an order in the department. I proposed to file an appeal. It is something very interesting issue. I proposed to file an appeal which nobody wanted to do. And luckily, the chairman agreed. And we got the order again modified. And in appeal, about 94 crore rupees were more paid to the government department. And I am happy that a very good amount, more than 400 crore rupees, the government department has recovered from that client. So this all happens because of the, sometimes the luck, sometimes the hard work, sometimes your reputation, sometimes your relations. But somewhere someone is sitting who is deciding our destiny and he is doing all these things. I don't say anything special with me. It's all Almighty who has done it.
Sir, on that note, I cannot stop myself but ask you, all of this going around, definitely there must be some stress. I know not that much with your kind of thought process, but still, how do you come out of that kind of stressful situation? How do you take care of yourself, your mental health, and what kind of hobbies do you look forward to when you want to de-stress yourself?
The very simple process which I am doing, I don't know. For so many years, in the morning, I get up after getting fresh, and my routine is that I do my pranayam. If I get time, then I go for meditation. Then for last 3-4 years, I am doing Sudarshan Kriya also. Guru Shri Devi Shankar's. Whenever I get time, I also do my yogasana and my walk. Whenever I get time. In the evening, if I get time, I would like to spend a good time with my wife. My children are well settled. So they are settled with their families. So I have only my wife to help me. So I spend good time with her. We are more friends than husband and wife. And enjoying life beautifully. Before Corona, we were going at least 4 times or 5 times in a year out of country and 4 or 5 times in the country. After Corona, now I started again going. We are going to Thailand and Cambodia only 2 weeks before. Now we are planning to go to US and Canada next month. So you have to take out the time and you have to choose the company, and the God has already chosen the company for me. So my wife is there to give me. And as far as hobbies are concerned, I love reading. Sometime late night, I read the books of my choice. Previously, it was good literature, history. Nowadays, it is spiritual books which I am reading.
Oh, sir, God bless you and your beautiful partner who is more your friend. Because if you get the friend in your partner, that's the best life one can lead. And Really, I'm so happy to hear that particular thing. May God bless both of you and your kids as well. Sir, and on that note, I would like to thank you for giving us so much of time of yours from your busy schedule. And once again, thank you for appearing on Super Lawyer. I hope you enjoyed the conversation.
Thanks to you, Divya. You did so much, asked me so many questions and tried to find out a lot of things which I have forgotten again to recollect and then to share with you. We will sit some other day. There's many to discuss with you and share with you. So nice of you. All the best for you and for your super lawyer and everyone associated with you. God bless
Thank
you.
you so much.
God bless you. Be happy, safe, successful.